Please. Yes, Lorships, the petitioner, the review petitioner before your Lordship was declared as a foreigner in 2016 by FT 5th Morrigan. And that was only on the ground that the notice which was issued to him, it was by the name of Mr. Abdul Rashid, son of Kamaluddin. And all the documents that the petitioner had provided there was relating to Abdul Rashid, son of Abdul Razak. So therefore, all the documents that he has provided were brushed aside, saying that because we are searching for a person and we are trying to determine the citizenship of a person who is son of Mr. Kamaluddin. So therefore, as you have provided documents of son of Abdul Razak, therefore, this will not do any good to you. And being agreed with that, a review petition before the Foreigners Tribunal Morrigan 5th was also filed, and that was also dismissed.
We are seeking a review of the 18 order
2000, yes, 2008.
after 7 years.
We are seeking a review of 18 order, and we have also preferred an SLP against that. And that SLP was withdrawn with a liberty, and that perhaps Lordship has already seen. That is in page 119. And when this order of SLP was passed, we were in detention. We were in detention for 2 years, and
SLP was withdrawn without informing the petitioner. The council on his own had withdrawn it.
yeah, they had.
Why?
We were in detention, so there was of course some communication gap.
No, your statement here somewhere I've seen
Yeah.
that you're not aware about withdrawal.
Yes.
You are hoping that
Yes.
something will come up, that
Yes,
somebody
yes.
withdraw on your behalf.
Right.
And another statement also at paragraph or page 25 says that drafting of the review took about 14 days, and along with condonation petition, and the same was filed on 3/3/2025. Is there any separate application?
At that time, actually, we thought the separate appeal would be needed, and we filed that, but the registry said that it is not necessary, so we took it back.
Not necessary. Why? And you can file anytime review. We understand that Supreme Court says that you may go and file review.
Yes.
Doesn't mean that you file review just like that. There has to be some explanation, isn't it?
But
7 years is a long time. We have forgotten what is what now. What is your ground for review? You have taken how many grounds?
primarily, if I
Just
say,
before you answer that,
yes,
you said that you filed review before the tribunal.
yes,
When was that? Before filing writ petition?
yes,
While you were pending there? I mean, while after disposal,
after disposal,
immediately after disposal, you filed review.
right?
That was informed to the court during the pendency of the writ petition that you had filed review, but it was.
No, again, after the review was over, only then we came before this court in the writ petition.
Okay.
You filed the review on the stipulated time.
There.
Dismissed.
Do you have a copy of the SLP with you? SLP.
That I don't have.
How did you draft this then? We would like to know what grounds you have taken before the Honorable Apex Court. which ultimately made you decide to come back here? What was the reason?
Now, Lordship, if I tell about my ground here, um, from the impugned judgment, I can say how I would beg to differ or what new things we have brought in is that here in the judgment, in the impugned judgment, it was said that we don't have a voter list wherein we have our name along with our parents. That was one of the grounds for dismissal of the writ petition. But actually, what happened at the time is that when we applied for certified copy of the voter list, only a portion of it was given, wherein more than 4 or 5 names it was not given. So now we have taken out the other names, wherein we can say that in the same list of the same year, yes, father, mother, and the petition.
Okay,
all
okay.
the
See,
names
factual
were-
aspects will come to that, but in principle,
Yeah.
does your review petition qualify as per the Order 47 Rule 1? Are those ingredients available?
So that lordships,
And that this review is not in a disguise of an appeal.
no, it is not. We have brought in, there was discovery of new materials, which was not at the knowledge because it's his parents' voter list. So he did not know whether everything was clear. After in the review judgment, when in the writ petition judgment, when we came to know that yes, this is one of the grounds that my name along with my parents was not there in a single voter list. That was one of the grounds taken. And thereafter on search, we have found that yes, in 1970 voter list, it is there. All three of our name together was there.
Okay, just a minute.
No, 89.
We know. It's outside. No. Okay, but that's your going to do.
Yeah. Right. Right. Oh. Yeah.
Mr. Payang, you were there for the other side. See, would you like to file an objection to this?
No, in fact, delays their review.
That is why
Yes.
we'll leave the maintainability part open. As on today, we'll not say anything. You may file a short objection if you want to.
Yes, yes.
We'll have one more date and perhaps,
Again, in the
Subject-
meantime, we will file an objection.
yes. All right. Your good name?
MK Chaudhary, Manjul Ketwal.
M.K. Chaudhary. Heard Mr. M.K. Chaudhary, learned counsel for the review petitioner who submits that by filing this review petition, under Chapter 10 of the Guwahati High Court rules, read with Order 47, Rule 1 CTC, the petitioner seeks review of the judgment and order dated 27/9/2018, passed in WPC number 7413 of 2016. Stop, next para. The learned counsel submits that pursuant to the passing of the judgment, the petitioner approached the Honorable Apex Court where's the number? By filing SLPC no, by filing special leave to appeal bracket C number 2706 of 2019. Stop. However, the SLP was withdrawn by the petitioner on 10/2/2020 with leave to file appropriate review petition before this court. To stop. Hence, the petitioner is before this court with the instant review petition. Next para. Having regard to the grounds taken for the review petition, let notice be issued, returnable by 6th of September. 4th of September, sorry. 4th of September. Mr. J. Payang, Lanet,
Standing counsel for,
Standing Counsel, FT,
yes,
FT matters, accepts notice on behalf of the respondent numbers,
two,
only two.
2, 4, and 6, 2, 4, and 5, man.
Respondent numbers 2, 4, and 5. Mr. M.R. Adhikari, Lanet CGC, accepts notice on behalf of respondent number 1.
3 by man. 3.
Mr. P. Sharma, Lanet Senior Government Advocate, Additional Senior Government Advocate, accepts notice on behalf of
Respondent number 3.
respondent number 3. Notice is therefore complete. Mr. Counsel for the petitioner, see, presently you don't have deputy commissioner, isn't it? It should be district commissioner.
District.
Yes, the respondent number 3. So you will correct this. Within 2 days, you file the amended cost title. You change deputy to district commissioner. Otherwise, there'll be some problem is there in uploading the thing in the CIS. Within 2 days, you file the amended cost title in 2 sets. Okay. Next para. It is noticed that the petitioner has arrayed Deputy Commissioner Morigaon as respondent number 3. But the court has been informed that the nomenclature Deputy Commissioner has been changed to District Commissioner. Now, stop. Therefore, the petitioner shall file the amended cost title showing respondent number 3 as District Commissioner Morigaon, Assam in 2 sets within 2 days. Next para. The issue on the maintainability of the writ petition is kept open. List the matter on 4th of September. Okay.
Published. Wait, Lordship, I beg to mention item number 29, your Lordship. Lordship, on Friday, I circulated adjournment slip, your Lordship. 29, your Lordship. Highly obliged.
May I please, Your Lordship? Your Lordship passed an order directing the SP to conduct an inquiry whether the suspected custody is the petitioner or not. And that matter, my lord, was fixed on last Friday. That was not reached. Can it be taken? Can it be taken tomorrow? Because day after tomorrow is the date fixed in the file. Tomorrow night.
I'm paying for listing of a matter, my lord. Then next week, Monday, my. Okay. May, your lordship. I let me mention item number 32. And the adjourn for your lordship. Problem.
Please, Your Lordship. I beg to mention item number 36 and 37 for adjournment for a week. Arguing counsel is out of station.
I beg to mention for item 12 and 15. May I pay for listing the matter on Friday night? Well, for 18. My lord.
There'll be some disruptions this week. That's why.
Then Monday or next week. 12 and
Master, you give it to the court master, they'll adjust.
12 and 18.
They will adjust it and they'll tell you.
Well,
Yes. Eight people.
Okay, kindly adjourn the matter of the day. We file additional leave petition. 2019 matter, you can't be permitted to file additional affidavit just like that. We'll file some voter list, pardon me, we'll file some voter list with the parents of the petitioner. Kindly, but those, you see, all the documents which were a part of the evidence, you already have it here. Petitioner's father's name has appeared in the voter list of 1966, 1970. How does it help you? Let us say you produced 10 more voter lists. How does it help you? Or establish the linkage with the petition. But we are not actually, we are not the foreigners tribunal to exercise original jurisdiction. We're just looking at whether the tribunal's orders were right or wrong. Whether it suffers from any perversity. Do we have the jurisdiction to examine fresh document? Do we have that jurisdiction? If this honorable court permit to file additional affidavit. Please repeat again. If this honorable court permit to file additional affidavit. No, if you left, if you had left out something, this is a 2019 writ petition. You should have immediately told us. After keeping this matter here for 6 years, is it permissible for us to send it back? Can't do that. That petition, that prayer has to be outrightly rejected. You see, because this is after 6 years you are making that prayer. Now we give you again time to file an affidavit, then we'll have to consider that. You are having a 5-year plan. Just like the government, Niti Aayog. We can't permit that, I'm sorry. You have to make your submissions on the basis of materials available on record. What is the voter list of yours with your projected parents? Voter list of 1966, 76, 85. The petitioner's father's name here till 1997. 97. This is father's name is Bazaruddin. Who is he? He's the father of the petitioner. And the next name, Hajirun Nisa, who is the mother of the petitioner. Is the mother. And your voter list with your projected parents? Petitioner's name has not appeared in any voter list. Several times he applied for listing his name in voter list. And then finally his name appeared in 1997 as D. 1997 is Sukur Ali. Sukur Ali is the elder brother of the petitioner. He is adduced his evidence as DW2. No, we are more interested in your voter list. Where is your voter list? Not there. In 1997, there is two voter lists. One is father of the petitioner, Bazaruddin and Ajernesa mother. Other voter list annexed 7, Shukur Ali as DW 2. Annexed 9, one is certificate, Panchayat certificate, annexed on page 41. And president of the Panchayat, he was examined by the tribunal as DW 3. How do you connect yourself to your projected parents if you don't have a voter list together? Petitioner's name has not listed with the parents. Only one certificate has next to another 9 is 41. But in 2016, you are 48 years. Voting age is 21. So for 27 years, you don't have a voter list. Yes, it's fine. Are you relying on any case law?
Yes, your lordship has.
Yes, are you relying on the case law? Are you relying on any case law? No. Okay. Like some. Fine.
But to link himself with his projected parent, there is no documents of all. He has not introduced, in fact, in WS, he has not introduced any document to link himself with his parent. So now, during the evidence, it is his claim that he has brought the consent certificate to link himself. And consent certificate, it is settled position of law. That consent certificate in Rupajan Begum Milo, Supreme Court has said consent certificate can be used by the woman to show that she got married from and shifted from one place to another after marriage. To establish that fact only, consent certificate was allowed for limited purpose in the NRC procedure. Otherwise, the consent certificate is not. Otherwise, there is no. And as your lordship has seen, and from affidavit also, affidavit shown by the petitioner, page 22, my lord, it is seen that he was aged about 52 years in 2019. So if he was 52 years in 2019, his date of birth will be sometime in 1967. So if he is 1967 born, he could have last put, my lord, up to 1989, it was 21 years. So he name should have been there in 1989 totally, at least. Since 1989 to till date, my lord, there is nothing to do.
And it's good. As well as the comments. By filing this petition under Article 226 of additional engagement as assailed the opinion dated page 55, 10/1/2019, passed. So, never declaring the petition to be a form of guidance. At the outset, the London Council for the Petitioner had prayed for an adjournment to file additional affidavit and bring on record additional documents. Said prayer was refused. You see, that has been removed. Because because in order to challenge the opinion dated 10/1/2019, the present date petition was filed on 9/6/2019. And therefore, the documents sought to be introduced, not being the exhibited documents before the learned tribunal, the prayer is refused. I think we are in the first few. Next one. On receipt of notice of the proceedings, or petitioner had appeared before the learned tribunal, and he had filed his written statement and had stated that the case is false and that the petitioner had adequate proof of being a citizen of the country. It was projected that the petitioner was born at village Bagmara, BHGH, MERO, Bagmara, Char, Moza Bagmara, TS Alopati, ALOPATI, Char, CHR, in the district of Bagmara. The name of his parents is Bajar, BAJAR, Bajar Adi, and Hajiran, AJIRAN, Hajiran Nessa. His names were enrolled in the voters list of 1966, 1970, 1985, and 1997. And that the name of his brother namely, Sukur Ali was enrolled in the voter list from 1985 to 1997. And 2010. Finally, is evidence on affidavit. This time, reiterated the stand taken in the written statement and had exhibited the following documents. 56. Serial 1 to 10. Exhibit A to A, Exhibit J. His examination the report from the petitioner was DW1 that he had not submitted any written document. Take before the tribunal. Next, the petitioner about to examine its projected brother named Sukur Ali as PW2, DW2. And he had also related statement made by the petitioner in his evidence on affidavit. Speaking. It's A to F. Equal to 856. Exhibit G. G. The average of on the field, and he had also exhibited his electoral voter ID voter identity card as exhibit H and G last as well as certificate of the Gamura of village number 1 from our Bagmara now within bracket exhibit 1 as well as the identity card of the next, which means also examine the on puzzle of Chodri C2 W PHU FZ A the president of the 72 number Bagmara Char Now Panchayat BW3 and we had exhibited his identity card as exhibit J. And that stated that he knew the petitioner since his childhood, as he was the neighbor. And he knows his parent And that we have drafted both since 1966. And the petitioner has an elder brother named Sukurali. And stated that exhibit F was into planning. And he had exhibited his signature within exhibit F within the plan. Provide his signature. In his cross-examination, he deliberately had stated he had not produced any relevant document for the tribunal in respect of the relevant voter list of the parents of the petitioner on the basis of which we had issued a certificate. Does not know when the father of the petitioner had died. Stated that he may have died 20 years back. And 12 years ago, his mother had expired. And we expected that as per his knowledge, the petitioner was 49 years old. Next, the direct tribunal on the examination of the materials available on the court. Observe that there were in the written statement, there was no specific pleading regard to the lineage of the petitioner. And he had only mentioned about the voters list of the year 1966, 70, 1985, 1997, containing his parents' name. And the evidence he had referred to he had added the name of the brother Sukurali, who's an enrolled voter in the year 1985 or 1997. Then it was observed that the petitioner had no feelings about his grandparents or other members of the family. Or when his parents were born and brought up, how many siblings he had. Accordingly, it was held that relevant facts were not pleaded by the petitioner. Learned tribunal established the certificate issued by the recipient of 72 number Agmarata Gaon Panchayat in embedded specific text of the ground that there was an unauthorized use of the state emblem in between the text of it. The renders the document not admissible. Moreover, was the issuing authority was examined by the recipient of the recipient of the certificate was examined. Moreover, it was held that the said certificate within bracket exhibit F was not issued by following the directions of the Supreme Court of India made in the case of Rupjal, RUPJAL, Begum versus Union of India and others. Is it something wrong? Miss Rupchandra Upajan. Citation at page 59. Is it incorrect?
Look, check that one. Rupajan, madam.
It will be Upajan.
Upajan.
UPAJAL. And can you read the citation? Oh, you got it.
2018, my lord, 1 SCC 579.
2018, one SCC.
Yes, 579.
2018, bracket one SCC 579. Is authentic, might was held that the exhibit F had no evidentiary value. Moreover, in respect of exhibit one, it was held that though the petitioner filed Gambura certificate as exhibit one, but neither the document nor its contents were proved. And moreover, the issuing Gambura was not examined. Accordingly, it was held that the petitioner had failed to establish his linkage with the voters whose names are enrolled in the voters list of 1966 and 1970. In respect of the evidence of DW2, learned tribunal questioned the credibility of the said witness on the ground that in the evidence on affidavit, his age was declared to be 53 years as on 14/5/2018. And as such, he was born in the year 1965. But in the electoral photo identity card, within bracket exhibit H, bracket 2, the petitioner was born in the year 1965, full stop, power, comma, as per the voting list of 1997, within bracket exhibit B, bracket 2, The DW2 was 39 years old as on 1/1/1997. And therefore, there was no explanation. Therefore, it was held that there was no possible explanation about the age discrepancy on the face of the file. Learned Tribunal also disbelieved the voter list of 1985 as in the year 1985 was found to be 18 years old. But in 1985, our lawful age of a voter was 21 years. Moreover, the voter list of the year 1985 was photocopied and not a certified copy of the voter list. And accordingly, the learned traveler disbelieved and doubted the identity of the 22. Next, the learned traveler held that the electoral roll was not proof of citizenship unless the claim is substantiated by cogent and reliable material evidence without any doubt. Is authentic with him that it failed to prove that he was a citizen of India and that's a 6 capital A of the citizenship. Reference was answered in the affirmative favor of the state. Petitions that we have partner of post 25 Next one. Even before this situation, the status of the petitioner remains unchanged. So he has shown no document whereby his name appears along with his parents. The entries in the voters list of 1966 and 1970 and 1997 in respect of his projected parents. Do not disclose the entire community. We disclosed only the names of the past. Raja Lee. And Ajidon Mesa. In the written statement, Krishna has not disclosed the names of any other siblings. 7 except his brothers, 2 only. However, said Sukurali, the name of Sukurali does not appear with projected parents of the petitioner. And his name appears in this terminal role. What is this from 1997? In bracket exhibit E. So in fact, this examination of in chief of DW2, he does not say that he lives separately from his parents. That statement is not there. There's a slight variance in the book number as regards the DW2 and your projected parents. There's no explanation why they would be voted if they are residing together. Why would they have a different voters polling booth? In the front list of 1985, a DW2 and his father, Bozor Ali, the same voter list. But after in the 1997, it is why do they have a separate voter list? It was living separately and another house number. They're living separately. House number is another 6, house number is 287, and another 7, house number is 288. There is 2 house number. No. That we can see from the documents, but in your evidence, have you disclosed that you are living separately? You have not stated that. DW2 does not state that he lives separately from his projected parents. However, the evidence in chief, the DW2 does not state that he lives separately from his projected parents. Next one. Yeah, in time to accept the submissions made by the standing person for the active matters, that a panchayat certificate is only to show the shifting of a married woman after marriage. And therefore, according to him, the panchayat certificate is not a substitute. It is not a proof of citizenship. In this regard, So apparently it's settled a judgment about Panchayat certificate not being approved for citizenship 2 days back.
My lord, it, Panchayat certificate. Yes, I'll just go.
Okay, in this regard, the glance can be placed on the case of so and so. Next. It is Dhanwara Beva. Dhanwara. Dhanwara. M-O-N-O-W-A-R. Dhanwara Beva. D-W-A. Alias Dhanwara. M-A-N-O-R-A. Beva. This is Union of India and others. WPC 2634 of 2016 decided on 28 to 2017. Wherein it has been held that the Panchayat certificate issued on the basis of evidence placed before the Secretary of the Gaon Panchayat is contrary to the mandate of the Assam Panchayat Act from 1994 and the citizenship within bracket registration of citizens and issue of national identity card bracket rules, 2003. Incites opposed to national interest. So moreover, the secretary will also help that such a certificate would be a private document in which in which event the author of the document would have to come and testify to prove the truthfulness of the contents of the said document. Be that as it may, in view of the unauthorized use of emblem of the country, the state emblem, said document, within bracket exhibit F is rendered inadmissible in evidence. F under the circumstance, except for an oral evidence of DW2, there is no cogent, reliable, and admissible evidence. So that the question is the son of his projected parents who had been legally staying in the country in terms of section which is that provision has to be continuous stay in the country.
My lord,
Continuous stay in the country, it's which provision?
my lord, 6C,
6,
Citizenship Act 6,
6,
6A and 6
6,
C.
6, 3B.
Yes,
Section 6, 3, within bracket 3, within bracket B. of the Citizenship Act of 1951.
Okay.
6(3).
Next. In this repetition, the petitioner is raised the plea of rights available in Article 21 of the Constitution of India, 6(8)(4), and has taken a stand that the petitioner is the right to have a fair and investigation in a fair procedure to be assessed by the learned tribunal. In the present case in hand, petitioner has not been able to demonstrate his link with the projected parent. In this petition, which was filed on 9/12/2019, while the petitioner was 52 years of age, and therefore petitioner would have been born in the year 1947 and would have become eligible to vote after 1970, after the year 1978. However, the petitioner has not exhibited any document to show that he was a voter along with his projected parents. And moreover, the petitioner has even not stated about the date or year when his parents had expired. Therefore, now the essential facts have been pleaded by the petitioner in his written statement, proved by way of evidence on affidavit on PW 1, 2, and 3. Next. One of the plea taken in this petition is that there was no clear investigation by the inquiry officer. So in this regard, on the perusal of the report of this, form of reference by the Superintendent of Police within bracket border, bracket was Propeta, which is available in the records of the tribunal, learned tribunal. It is seen that in column 11 thereof, the said authority has made a mention that the annexure A and B of the report of the electoral registration officer are not completed in all respects, and due to incomplete information, it is not possible to furnish clear-cut opinion as to the grounds. Therefore, no, not therefore. In this regard, It may be expected that in this case, or as per Annexure B to the report of the electoral registration officer, which is dated 1997, it has been mentioned that the Election Commission of India had ordered intensive revision of electoral roll for the Bagbor Assembly constituency. In Assam with reference to 1197 as qualifying date. Pursuant to the report of the ARO, reference was made by the Superintendent of Police Borpeta. IMDT case. IMDT doubtful case number 6483 of 98 was registered against the petitioner. As per paragraph 1 of the imperial opinion, it has been mentioned that pursuant to orders passed by the Supreme Court of India in the case of Sarvana and Sonwar versus Union of India in bracket 2005, it was 5 SCC 665. IMDT Act was and rules framed thereunder was declared to be ultra vires and all the cases pending before the said tribunal were transferred before the foreigners tribunals. Which, under the circumstances, the jurisdiction of the learned foreigners tribunal to adjudicate the dispute as a reason of the orders of the Supreme Court of India. And therefore, the said issue cannot be reopened by this court. Next, court is not breaking the there's no publicity is found in the opinion rendered by the tribunal. Next, is this court is exercising secretarial jurisdiction. It will not be permissible for this court to examine any fresh documents. Petitioner before the learned tribunal. And moreover, no review was filed by the petitioner because the said learned tribunal to do very fresh documents. What the process time is fixed. More as to how. Copy of this order be transmitted to the Learned Foreign Tribunal number 6, Orbital. Along with the copy of the sample to be made a part of. Along with the records, those to make the same as the part of the report.
My lord, could you this one judgment of Honorable Apex Court recently passed, my lord? Very- Recent judgment of Honorable Apex Court in FT cases, my lord, where the that there are 6, 4, 5, 6, 7 my lord, new documents in no manner to be allowed.
Which, if you cut to the documents, last part of the order, you are more at. In this regard, this is grant to the decision of the decision dated 3/3/2025, asked by the Supreme Court of India in SFP within bracket civil, SFP diary number 41389/2024. In the case of Jalal, 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 next word, Uddin, UDDIN versus Union of India and others. Paragraph 7 thereof supported to. Okay.
Yes.
Population count. Or Mr. AHM. Because the respondents are there. You get the names of respondents. Focus on duty. Next paragraph. When this matter was last listed on 27/6/2025, the learned CGC had informed the court that Raham Ali, RAHAF, Raham Ali, son of the petitioner, was handed over to the sector headquarters, BSF, Kuch Bihar. And thereafter to the 157 Battalion, DL, that will be smaller, BSF, said declared foreign national was sent back to Bangladesh from the AOR. With the area of responsibility, packet code, comma, border outpost, Tilak, EILAK, district which we are. On the intervening night of 26th of the 27th May 2025. According to our instructions, receive and count for the petition. This petition stands closed without prejudice to the right of the petitioner or the deported or not to take any of the steps that may be permissibly employed in respect of the said Prahamadi declared for national. It will be debated to whatever you want.
Publish.
This because it's and dispose.
This matter came up last Wednesday, Your Lordship. Your Lordship was about to deliver the order, then Your Lordship asked me to change the nomenclature of respondent number 5, Your Lordship.
Where is the, which page is the opinion?
Opinion is on page 68. You know.
You have amended the cost item.
Lordship.
You have amended the cost item.
Lordship. Lordship.
Ms. Burman, you know, where and we hear the matter.
Last that lordship were issued rule, increment hearing was fixed, then lordship saw that it was not done.
But Mr. Can I say that?
MD, I would say.
Mr. Ayub, sir.
MD, I would say. Mohammed, I would say.
Okay. You see, when you fill up the form, that's why we always ask you your name. Correct. Because whenever you fill up the form, you always write Mr. I Hussein. You look at this.
Yes, Your Lordship.
No, we don't, either you don't take care of a clerk or he doesn't take care of you. You see, we'll show you this. That's why it always
I'm
happens.
sorry, Your Lordship.
Either we write MI saying that's how you write your name in this. You see this form.
Yes, Your
You
Lordship.
check up this form. You again check up the first page.
Lordship.
And you'll find it.
Lordship, recently, Your Lordship, I have been very
That we don't,
cautious about it because it was a 24, Your Lordship.
no, that we don't know, but this is how you do it.
Yes, Your Lordship.
You see in this first page, which is normally filled up by you,
Lordship.
this title page, first order sheet, where you write Mr. Very clear, MR, correct. And in this form, filing slip, you again write Mr. In the checklist, you write your name as Mr. Three mistakes can't happen.
I'll take care of it.
Take care of your back. MD heights. For the responsibility. Next. Question to order dated 23/7/2025 of the London Council for the petitioner has amended the cost title in respect of respondent number 5. Next. Next is paragraph 2 of order dated 16/2/2024. Paragraph 2 of 16/2/2024. Next one. Pursuant to order dated 16/2/2024, the records of the tribunal is received. Accordingly, court is inclined to issue rule returnable. Without requiring the petitioner to take the steps. However, extra copies, you have the extra copies?
One copy, maybe it's furnished left.
One extra copy of the revision along with all the information be provided to A. Verma and standing counsel for the appeal. Next. This is the matter for hearing. In the week commencing. In the last week of August 2025. Sure. This- Last week. The London Council for the petitioner has paid for bail, which is opposed by the London Standing Council for the appeal. Next. Considering the protection made in this week. What is the plan? And taking from the. Just so. Take the form from the my secretary. Bail of rupees 10 days time to take bail of rupees 5,000. To the satisfaction of Supreme Police within packet order. Packet post. This place.
You have also the SP Sonic.
Solid. There are conditions, take those conditions for the secretary. Just in the week, in the last week of August 20. Yes,
My lord, this is habeas corpus petition. The present petitioner's father-in-law is Shahmod Ali. Petitioner is the son-in-law of that Shahmod Ali. Shahmod Ali was declared as foreigner by the landed tribunal. Then he filed a writ petition in High Court and High Court dismissed the writ petition matter. Then he went to Honorable Supreme Court. That's page 22 is the order. Case the SLC was withdrawn with liberty to file a review petition. That is page 22. In the meanwhile, my lord, following the order of the landed tribunal, he was taken into custody. He was more than 2 years in detention camp at Tesco. Thereafter, he was released on bail, perhaps on the basis of Supreme Court's order. Again, on 23, my lord, police personnel from Dolgao went to his house and picked up. 23. Then 24, he was allowed to go home. Again on 25, he was arrested and taken to unknown distant destination. So in such a situation, my lord, we are worship.
get the information.
Instructions were.
And we may be allowed to see the person if they inform us.
Lordship, let us first
So
get
first of
the
all, they'll have to
instructions.
disclose, then only you can meet.
Then Lordship kindly fix a short date because he's a very old man. And clearly he is very,
But Mr. M. Mahmood and counsel petition on the responses of the
So, extra copy I will give you.
petitioner is the son-in-law of Sahamat, Sahemat, Sahamat Hussain, who was declared to be a foreigner of post 25 in 1971, but to be an illegal migrant of post 25 in 1971, by the opinion dated 28/4/2017, passed by the learned member of a Foreigners Tribunal, Darang, Mangalday, in case number, page 12. Case number so and so, SP inquiry number so and so. Next. The said opinion was unsuccessfully challenged by filing WPC 6452 of 2018, which was dismissed by order dated 27/11/2018, and SLP prepared against the said order was withdrawn. With liberty to file a review petition.
You can approve, no? So.
It's not known as to whether any review petition was filed thereafter.
Postal ID, no?
Next, will be the resignation. The said Sahamat Ali was taken into custody on 25/5/2025 and his whereabouts is unknown. Next, accordingly. The learned Stanicus for the FT matters shall obtain instructions from the concerned authorities of the Home and Political within the Police Department, Government of Assam. And in the meanwhile, the learned CGC shall also obtain instructions to the said declared foreigner was deported out of the country. Next. The learned standing for the FT matter, the learned counsel for the petitioner shall provide one copy of the writ petition along with one soft copy of the writ petition to the learned standing, learned CGC as well as to the learned standing for the FT matter, which will enable her to obtain them to obtain instructions. This round. Yeah, tomorrow.
No, Friday, Lordship.
Friday we have some difficulties.
Okay, we'll try. Let him serve the extra copies.
we will sir.
Hard copy.
Afternoon we will sir. Last time we are maximum busy.
In course of the day, so what?
Yes, we will supply.
At least we can do it is on Thursday.
Lordship
then.
will fix it for Thursday, Lordship.
This month, Thursday is 31.
Nice.
Yeah, please. This petition is filed by the husband of the petitioner. He can be my lord.
When the petition, when the
He
husband was
was
arrested,
taken into custody on
27/5.
yes, 27/5.
This will be similar, will be similar, but I'll give you detail. But Mr. S.A. Ahmed, and counsel for the petitioner, all the respondents are there. Next. The petitioner is the husband. Of Muhammad Emio SSTT Hamida, HAMIDA, Begum. Which page is the opinion?
Number the page 39 now. That's what the opinion was passed.
Was
Party opinion, Lordship of 2018.
declared
Yes, the Honorable High Court. And
it's party opinion. It's party opinion that it was declared to be Hama was declared to be a foreign, was illegally entered into the territory of India within bracket Assam. But it was after 25/3/1971. Right, opinion dated 4/12/2018, page 39. 4/12/2018 passed by Leonard so-and-so in case number so-and-so corresponding to SP inquiry number so-and-so, or thereby declaring. No, who's wrong? Only. That's the case of the petition is that his wife was taken into custody on 27/5/2025, and since then her whereabouts is not known. Next. The learned standing counsel for the demand shall obtain instructions from the concerned authorities of the Home and Political P Department. The whereabouts of the said declared foreign national. Moreover, the Ghana citizenship was obtained instructions to whether it said declared foreign national has been fulfilled of the complaint. Next, in the meanwhile, the learned counsel for the petition shall provide copy of the date petition as well as a soft copy thereof to the learned standing counsel to the AP matter in this preliminary citizenship. Enable them to obtain instruction. Next file is going same
31,
31.
31.
Give a copy today.
the here, Sam is the petitioner.
Which page is
Father
the
was
opinion?
cleared as per him.
Which page is the opinion?
He is my lord. But 52, my lord.
Hmm?
This is a common order, my lord. We start from 48, my lord.
Which page?
48, my lord.
48.
Yes.
And your name is at?
MD Abdul Ali, my lord, in page 48. Serial number 1, my lord. This is a common
Okay.
opinion.
The proceedings name is Abdul Ali,
Yes.
number 1.
Number 1.
Okay.
And his son is petitioner.
It will be same. Order will be same. Only the particulars are, I'm changing it. Petitioner is the son of Abdul Ali. Opinion against him is at page 48. Passed by so and so. I'm putting a tick mark, passed by so and so. In serial number 1, in case number so and so, corresponding to SP inquiry number so and so. Thereby declaring him to be an illegal migrant of post 19th century. Son of the petitioner was taken into custody on. You are the son. Father was,
Yes.
father is declared. Okay.
Son.
Father is the declared. Is the son of so and so. Now, the second, now you're right. The father of the petitioner was taken into custody on 25/5/2025. Rest of the order will be same. Same date, 21. 7/20. Rest of the order will be same.
Yes, my lord, there is also son of the detainee's petitioner.
Petitioner is the son.
Yes, ma'am. The expert
Opinion is at
opinion was
which?
passed.
Opinion is at page
At page 36, ma'am.
36.
Expert opinion.
Consolation, Mr. S. A. Ahmed. Petitioner is the son of Muhammad Ayub Ali, alias Ayub Ali. Ex parte opinion against him is at page 36 by so and so, case number FTG number so and so, corresponding to SP inquiry number so and so. If I declaring petitioner's father to be illegal migrant was entered into India within bracket Assam after 25/3/1972. Taken into custody on 25/5/2025. Border branch of the Merapani, MERAPANI police station. Rest of the order is same. Same date.
Your daughter is the petitioner now.
He's the daughter-in-law. The petitioner is a daughter-in-law.
Daughter.
Daughter. Where is the
Opinion at
opinion?
page, my lord. 30.
Mr. S. A. Ahmed for the petitioner. Petitioner is the daughter of
Jahira Begum.
Jahira, Jahera Begum, a wife of late Barek, Barek, Barek Ali. Was declared to be a foreigner was entered into Assam within India on or after 25/1971. By opinion dated 26/2/2024, page 30 by so and so. In case number so and so, police inquiry number so and so. Mother of the petitioner was taken into custody on 25/5/25 by the border police under the Superintendent of Police, in bracket border, that is Sulakar. That's what they always say. Okay. Extra copies.
Oblige, my lord.
Yeah, Your Lordship. Lordship, MP Nadar at page 62, my lord. Lordship. On the last occasion, Your Lordship, classes and materials on the part of the petitioner after filing and petition, my lord. And in this case, my lord, I submit, my lord, the petitioner earlier contested the case before the land tribunal, my lord. And he was declared as not a foreigner by the order dated, my lord, 5/6/17, my lord. Due to the administrative page 61, my lord. Lordship. 5/6/2017, my lord. He was declared not a foreigner, but there is the opinion will follow the separate statement. That has not been.
Lordship, there were number of matters
Lordship. That is
like
what.
this, so High Court so moto
So
took
what
it up.
has been filed before
And
the.
these matters were reheard and by the tribunal again, where no separate order sheets were there, Lordship. What he's referring to at 61,
Lordship.
we have a complete list, Lordship, all those matters which were sent back. I think my friend will have
Yeah.
the WPC order. Even if we look into it, we'll find it. You have that petition order?
So
moto?
moto, yes.
How the difficulty is that there is another opinion which has come. Now, we don't know.
The Honorable High Court, my lord, the
Lordship,
sumoto case, my lord, one.
This
should be
is
one.
Oh, no, this is the same thing. No, we've got it.
What?
Please come to page 62.
Lordship.
In page 62, last 3 lines.
Lordship.
It was registered as case number 344 of 15. You got it?
Yes, Lordship.
And now come to page 60. This is 344 of 15. Same thing. And therefore it says,
No, the main order which was first
Lordship, height order, my lord.
61.
Let's, page 61, or height order 7/2019, my lord. There is, my lord, no, there is sumoto case of this Honorable High Court, my lord.
That is
Uh,
Sumoto
one
1 of
of it to
18,
page
Lordship.
number,
61, my lord, below, my lord.
Lordship, this Sumoto number is 1 of 18. I can produce this order before
no,
we
it's not
discuss.
required because this is already there.
Lordship.
In page 62, it
Okay.
refers to 344 of 15.
Lordship.
Therefore it says it's been transferred. But once it is transferred, they passed a fresh opinion.
Lordship,
two,
Lordship,
case was
High
thus
Court
received
directed
on-
these matters to be heard afresh.
After.
That
No,
was-
we understand that. Therefore, we don't need anything because paragraph 2 says reference received on transfer. And so therefore his opinion is passed.
Order sheet.
Therefore, the challenge to this, you have to choose explanation why 28. There was a delay in challenging this opinion of 28/2019.
Lordship, in this matter, my lord, I submit my lord, the petitioner is a very poor person, my lord, and I'm due to condemn it, lordship. As he was suffering from financial hardship, my lord, that is, he could not appear before the learned, court below, learned, honorable high court, my lord. And in the article 226, my lord, your lordship have the discretionary power, my lord, to delay, my lord. And in this regard, my lord, I project one target of the apex court, my lord, recent platform, my lord. And paragraph number paragraph number, lordship, 46, my lord, and page 35, yes.
Yes.
And on the question of delay in filing the writ petition before the High Court, my lord. Lordship got it. Paragraph number 36, 46, my lord, page 35.
In this
Lordship,
is
the urban improvement,
paragraph 35,
page 35, my lord.
page 35.
Lordship, paragraph 46. my lord. Bottom, my lord. Page number is bottom, my lord.
Just a moment.
So, Tribunal party wala, maybe party wala. Last one, my lord, 13 December 2024.
This, the facts in this case does not apply. You see, there are many things that I will not remember. The land was acquired long back. After that, the payment of compensation was delayed. You did not receive compensation. Then they, this.
That is different, my lord.
Before the tribunal, that the 2 year of land acquisition had lapsed. And after this, there are proceedings, then the title was declared in favor of the appellant before the court. Board of Revenue cases were there. After that, series of writ petitions were there. Then this I had forgotten, that's why I was searching for it.
Several judgment is there, my lord.
And no,
Discuss, my lord.
tell you why this.
Paragraph number 47, 48 also, my lord.
No. Come to page 27, sorry, page 9, paragraph 27. This is something I was searching for. The appellant trust filed as SLP before the Supreme Court under SLP civil diary number 29045 of 2018. Before this court, that means Supreme Court, which is still pending adjudication. So under these facts, when this declaration was held that it was delayed, under that circumstance it was said because the question in this case was regarding to the extension of Land Acquisition Act to the state of Rajasthan. The question of law. Therefore, despite 21 years of delay, it was not done. The Supreme Court has passed the order because of the fact that one of the litigations of such a long time, 2018, is still pending before.
Paragraph number 47 also, my lord, with the same line. On page 36 also, my lord. The delay and losses cannot be raised in the case of a containing cause of action, or if the circumstances shock the judicial conscience of the court, condonation of delay is a matter of judicial discretion. But your lordship has a discretionary power, my lord, under Article 226.
No, but you have to show cause. You are referring to pandemic.
And due to financial
Pandemic
hardship, my
is-
lord,
That also is,
he has a financial
something which
hardship,
is-
my lord, he's a very poor person, my lord. That is why he could not approach within time, my lord. And there is no delay, my lord, in approaching with our loving court.
you see, we'll have to adopt a criteria. Financial difficulties. Please tell us for how many years this Legal Services Authority Act
Yes.
is being
Lordship, there is,
promoted by
my
the
lord,
government.
the petition has no knowledge, my lord, about this matter, my lord. The legal service authority, my lord. I mean, in the lawyer code, my
Absence
lord,
of knowledge is not an excuse for a citizen.
lordship.
You can't say I'm not aware. And she must also disclose, she went to a lawyer and the lawyer refused. What was the fees charged? What is her capacity? Nothing is mentioned.
Lordship, my lord, lordship, because the question of citizenship, my lord, the lordship has leniency, my lord, in this matter, my lord.
You must have to go a cogent reason.
But from the exceptional case, my lord, there may be, my lord.
It does not say she went to a lawyer when she was charged more.
No, lord.
Couldn't pay.
That-
She
that
was
is
not,
for Piyama.
her lawyer did not inform her by giving the name of the lawyer about the free legal aid being
No.
provided. Questions are not there.
not mechanically, it is not the case that he didn't have the knowledge. Here's the knowledge when he appeared, there was a contested proceeding. Then my lord, after my lord, this opinion is passed, my lord, in 2019, he become my lord, silent. That means he accepted the my lord, opinion of the tribunal. Now, why they are coming, my lord? The real fact is that the government of Assam is trying to deport all these my lord, declared foreigner. Had there been no process of deportation, my lord, they would not have come. These all people are hiding. Your lordship will find another. There are another cases, but all are same put that due to financial money constraint, they could not come on that. Had there been no process of deportation, they would not have come back. They didn't care about this opinion for long. They thought, my lord, what will happen? No, but nothing will happen. Even though opinion is passed, we will remain here. No, madam, I'm not from there, madam.
That is not for the court to.
Now, why they are coming, madam? As the government is taking, madam, the process of deportation, now they are coming with this grounded due to financial hardship. We could not approach this honorable court.
Some Mubarak, we are disputing it. But Mr. A. Mubarak and part of the petition. Also, how to respond. By filing this petition on Article 226 of the Constitution of India, the petitioner, namely so and so, has assailed the opinion dated page 62. Opinion dated 28/6/2019, asked by so and so in FT case number so and so. Arising out of police reference the case number so and so. They were declaring the petitioner to be a foreigner of 425 speak. Next. As this petition was filed on 30/6/2025, to send the set opinion dated 28/6/2019 is about 6 years later. By an order dated 21/7/2025. Court had granted the grant counsel for the petitioner some time to address the court on the maintenance of the petition on the ground of unexplained delay and losses. The sale is set opinion. Next. The grant counsel for the petitioner has referred to the statements made in the petition, and it is submitted that the petitioner is a poor woman with no adequate source of income. Moreover, it is projected that during the pandemic period, the family of the petitioner had suffered immense, resulting in severe financial hardship, from which he is yet to overcome. It's submitted under such circumstances from our court. not to accept court will be pleased to accept the said ground as good and sufficient cause for delay in approaching this court. It is also submitted that the Limitation Act has no application to the petition. And it is submitted that where the order of the tribunal is patently illegal, and that non-entertaining of the writ petition would affect the fundamental right of the petitioner. The delay is required to be condoned. In this regard, the learned counsel for the petitioner has referred to paragraph 46 of the judgment and order dated 13/12/2024, passed by the Supreme Court of India in civil appeal number 14473 of the 2024. Second, arising out of SLP within bracket C, bracket clause number 12116 of 2010 dash Urban Improvement Trust versus Srimati SMT Vidya VIDHYA Vidya Devi and others. Paragraph 46 thereof is quoted. Next one. The learned standing up for the matters. It was the way making this on the number. In selling the opinion. In the present case in hand, it is not the case of the petitioner. In the Jahura Atun, yes. No, it is Jera, FEGJERA, FEJERA, Jahura Atun, KHETWL, alias Jahura, JHURA, Jahura Atun, KHETWL. That she was not aware of the passing of the opinion dated 28/6/2020 by the learned tribunal. From the photocopy of the certified copy of the opinion dated 28/6/2015, it is observed that the application for copy was made on 16/8/2019, and the copy was made over to the person applying on 5/9/2019. Therefore, petition is aware of the said opinion dated 28/6/2019 on and from 5/9/2019 and onwards. Next. insofar as the pandemic, the COVID pandemic period is concerned, going to orders passed by the Supreme Court of India as well as orders passed by this court. The limitation of fulfilling the orders during the pandemic period. I from 15/3/2020 till 28/2/2022. What is the period of extension of limitation for COVID? For COVID, what is the limitation extension? 15/3/2020 to 28/2/2022,
21.
or some other period?
Limitation period is up to 2021.
Hmm?
2021. 2020.
28/2.
Yeah.
22. Just check it out. Extension of COVID limitation. Was from which period to which period? Just check it out. I'll say you will know it. Person to MA number or order 10/1/2022 passed in MA 21 of 2022 in so motu MOTU WPC number 3 of 2020. You attached an in re column cognizance for extension of limitation in the case of urban improvement trust. Didn't get it supra. On a careful perusal of paragraph 46 thereof, it is seen that the Supreme Court of India has reiterated the law that undue delay in approaching the court can be a ground for refusing relief. And that only in exceptional cases delay can be condoned. In the present case in hand, Krishna has made only a false statement of poor financial condition. Which, however, Krishna has not been able to demonstrate. So why he was unable to take existence of legally counsel by approaching the competent authority in an appropriate manner. As provided under the Legal Services Authority Act. 1987.
Lordship, paragraph 50 may be
Paragraph
50 also. This 38 now. Of the judgment. Judgment.
page number
Page number 38 man.
38, paragraph 50.
50 man.
How does it help you?
It is a discretionary power of the Honorable Court, my lord. The Lordship may like this in the bottom, my lord, paragraph 50, my lord, is one of the discretion of this court to follow the from case to case. There is no lower limit and there is no upper limit. It will all depends on what the breach of the fundamental rights and the remedy claim are and how the delay.
It's not a breach of fundamental right.
Citizenship is a constitutional right also, my lord. Your Lordship has the.
Please repeat again. We do not get it. Please repeat again.
Is one of the discretion of this court to follow from case to case. There is no lower limit and there is no upper limit. It will all depends on what the breach of the fundamental right and the remedy claim are and how the delay arose.
We'll continue the rest of the dictation after that. We did not appeal. Rather, rest of the dictation is completing the code. We're discussing it. Paragraph 50, you want us to consider. Put in the chambers.
My lord, your lordship is dictating the judgment in December.
We'll dictate in the chamber because we have limited time and there are a lot
Yes.
of repetitions.
Not only in that case, my lord, your lordship may, apart from that aspect, delay. Your lordship may consider the merit also, merit is also, there is nothing.
Merit we won't go into. So if you go into the merit, we must examine the records and then.
Timeline to find anything that is in the ground for the
Delay latches. Both sides are represented on the pair made by counsel for the petitioner, list after 2 weeks was enabling to file. List after 2 weeks.
Lordship, I had filed a case challenging an order dated 20 to 2023, whereby the petitioner has been
Page,
page number of the last page number 34. He has been declared foreigner, but then your lordship, I want to withdraw this petition with the liberty to file a penal lawsuit because there is a mistake in annexure number 5, your lordship, page number 19. There is a typographical mistake in this page number 19, your lordship. Kindly let me withdraw this finally.
no, let me tell you. Is you, whatever you say, we'll do it. But please consider your writ petition is already delayed. Just number, no, please understand, let me complete. First of all, there is a delay. Second is that you can always make a prayer before the court and substitute this document. This page 19, if you say has a typographical error, you can substitute with the leave of the court, you can substitute it so that therefore you save your further explanation of delay. Delay otherwise also we may be harsh.
Substitution to recover by filing an application.
When it comes to the question of delay, we may be harsh. So therefore it is, you please take our advice. If you can, we can give you liberty to substitute page 19.
Yes, 19, page number 7. Then the number 7 also. There is a
Page.
one mistake in annexure number 7. In 19, 19.
Page.
Page number 23 of
You substitute this, it will be better because again you will have to explain the delay.
yes, I substituted.
Your name?
See, that's the lordship.
Ms. Pidas and counsel for the petitioner submits that a typographical error has crept in the type copy of annexure 5 and annexure 7 at page 19 and 23 respectively. Next, accordingly on our prayer, is the learned counsel for the petitioner is permitted to substitute the set page 19 and 23 of the writ petition with corrected copy. So the same shall be done before the DOJ FT section and thereafter the matter will be listed to the court. How much time do you have? 2 weeks, 2 days time? 2 week? No, no, 2 days, not more than that. Do it within 2 days. You have to have typing error. 2 days. 2 days time is good.
Okay.
Page is 7.
Which was off.
Please repeat again.
Lordship, page number 37, annexure 2, your lordship.
Yes.
Here, your lordship, what happened? The delay to approach this honorable court has not been pleaded in my writ petition, your lordship. So with due respect, lordship, I would bring on record the delay part, your lordship, for filing additional affidavit with due permission of your lordship.
We just adjourn it. We are not giving any permission. We just adjourn it for a week.
Lordship.
Also as represented on the prayer made by Ms. Chigwara and counsel for the petition. This properly.
Much obliged. Would you kindly pass over the matter for the day?
Give it to us, let's go, please talk. Let's break for a minute.
Next.
Seventeen.
My Joshua will find my the MP opinion at least 75 madam.
Age,
75 madam. Well, this opinion was passed on 12/12/2022.
take the format from. And this test how can I upload the petition, how the respondent's name, giving. Next. Take it from. Page 75. Challenge to the opinion dated 12/12/2022, passed by. Students, give and take marks. You may look at. So and so, in case number so and so, police reference number so and so, dated so and. I wish the. It's to be declared to be a foreigner for 25 in 1970. Notice extra copies will be included. The notice returnable on. After 4 weeks, will be returnable on, sir. Extra copies 2 days, let the relevant record be requested from the concerned traveler. Next. Prayer for bail shall be considered on receipt of the traveler's report. In the meanwhile, if the petitioner, namely Mohammed Qudus Ali, is apprehended and shall not be deported after the cutting without order of the list on. All right. Yes,
May I please, your lordship. Lord, the impugn order, your lordship will find at page number 102.
10.
102.
But he,
Yeah, I'll leave it.
doesn't count for the petitioner, or the respondents are there. Challenge opening is at page 102, dated 10/6/2025, asked by so and so in every case number so and so. Within bracket. IMDT case number so and so, that you will get that one. They were declaring the petitioner to be a foreigner of post 25. Notice returned within 4 weeks, or put it record. Extra copies will be 2 days. Prayer for bail is opposed by the learned standing counsel for the FP matters, which are our common. Considering the projection made in this. Petition, what is inclined to grant bail, in this time to take bail or rupees 5,000 to the satisfaction of. Superintendent of Police within bracket border.
Border.
Okay. Conditions. This transfer. 4 weeks. Conditions.
I'm obliged me.
May I please, your lordship.
Lordship, my lord, challenging the judgment and ordered by the learned member, my lord, on 13/9/2019, my lord. Base, my lord, 55, my lord.
55, that was on issue of maintainability. 2019 is 6 years now.
My lord.
This was on maintainability.
Well, I have explained my delay. My problem is that, my lord, your lordship may go to my paragraph, my lord.
Paragraph,
My lord,
paragraph number?
paragraph 11, my lord. Sorry, sir. Paragraph 18, my lord.
18,
18, 1/8, my lord.
page.
That the petitioner is a rustic person and studied up to 8th standard, having no basic knowledge and consequence that she can approach the higher judicial forum in the time of scrutiny of the opinion dated so-and-so passed by the learned so-and-so. Moreover, her father was a cancer patient and even after long treatment, he did not survive and died on 17/5/2019. The whole case was monitored by the father of the petitioner. Due to death of the petitioner father on so-and-so, she became a helpless daughter and she did not know about the father course of action about her case. The authority concerned have issued a death certificate in this regard. After death of her father and also being an illiterate person, she and her husband does not know consequences of the order passed by the learned tribunal. However, a co-villager has recently informed her that she can approach the High Court after getting the information. Your humble petitioner had collected a paper from tribunal as well as from her engaged counsel and handed up the same in a newly engaged counsel. There is not any intentional delay on the part of the petitioner in approaching the Honorable High Court. Even then, if this Honorable Court feels that there is a delay in filing the instant petition, the petitioner humbly pray before considering the same under the circumstances narrated here and above. This is my explanation. And
That explanation
this certified
cannot
copy was applied, my lord, your
That
lordship,
explanation
on
cannot be accepted.
2/6/2025, my lord.
That explanation cannot be accepted because you say that somebody you have stated here that after marriage, your husband also started residing to you at your parental home.
Yes, my lord.
So, but your husband is there. Even if
Husband
your
is
father,
there, my lord. He has total, actually whole case is monitored by my father, my lord. And father also deposed the evidence and father and grandfather also or is a citizen, my lord. And my lord, if your lordship go to the verification report, totally, my lord, without verification, this verification has been done by the, my lord, page, annexure 1, page 19, my lord. Nothing is written, only, my lord, name is Mamta's written, my lord. Nothing has been written, not fill up the whole file, and nothing in verification report has been mentioned. Last page 22, my lord. And
this is the case which has been referred, by the electoral registration officer.
my signature and local verification officer with full name and agent, my lord. Please, page 22, my lord.
No, you are not following the question,
My lord.
what we are saying. You see, in this case, the reference was made by electoral registration officer. So he is not required, he is only have to create a doubt on the name which is appearing in the voters list.
My lord. But your signature is only, my lord, is only one there. That is the signature of the local verification officer with full name and there's nothing.
We have already decided this issue in.
Yes, my lord. On the other hand, my lord, my school certificate also, my lord, as a, my lord, given my exhibit, my lord, our school headmaster also, my lord, give the evidence, my lord. So I pray before lordships at this stage call for the record, my lord.
If there's a delay and it's not properly explained, may not be able to, may not call for the records.
And the delay is there, my lord, but the entire case record was monitored about that my father is doing, my lord. And after expire of my father, my lord. And father evidence is also there, my lord, in DW2, my lord.
Where is the reference by the ERO? Which page?
My lord.
Where is the reference of ERO? Electoral registration officer, where is the reference?
Electoral registration. No, my lord, electoral, that page, my lord, this letter, page 19, my lord. Your lordship go to page 19. To the electoral registration officer by the, my lord, verification officer. And nothing has been, my lord, verified.
Which page is that?
Page 19, my lord, page 19. No report, nothing, my lord. Did not mention any stream also, my lord. The police did not mention the stream of which he belongs to, my lord. And verified report, my lord, itself, my lord, is a vague report, my lord. And every column is blank, my lord. Your lordship go to the 21, 22, my lord. 20, 21, and 22. And signature is there only AERO. And no verification has been done, my lord. I have a voter my card also, and father also, my lord, is a 1966 voter is their grandfather, and father is also there in 1971. And last, my lord, NRC also, my name is there, my lord, and I also voting, my lord, my I card is also there, my lord. And I was born, my lord, 5185, my lord. My lord, section T1A of the Act, my lord. Born by, my lord, a person born in India between the period of 26 January 1950 to January 1st July 1987, my lord. She is born on 5/1/85. That was also reflected in the school certificate, my lord. And its headmaster also deposed before the tribunal, my lord. That was also not considered, my lord.
Where is your written
Honorable
statement?
court, will you please go through the,
Where is,
and my lord, advocate of the state is not engaged regarding that.
where is your written statement?
WS, my lord, your lordship, go to. Written statement, page 23, my lord. The opposite party, Mumtaz Begum, Mohammed so-and-so, Indian citizen by birth, is a regular voter of 74 Rangapura LAC, possessing the electoral photo identity card, so-and-so. The above case is not at all maintainable present from under provisions of the Foreigner Act, so-and-so. The opposite party is not a foreigner, and allegation made against the opposite party are false, so-and-so.
I will tell you
This
something.
section,
Please come to this. Come to your page 36.
my lord. 36, my
In
lord.
your evidence, you say
My lord.
you are a resident of village Gudam Ghat,
Yes, my lord.
correct?
Yes, my lord.
And then you say you are married at paragraph 2, page 36.
Yes,
You
opposite
say
voter.
that you were married to so-and-so village, Akabasti, Bengali.
Yes, my lord.
Correct.
And thereafter again shifted in my
Please,
parental house, my lord.
Don't be so hurried.
My lord.
Don't be in such a hurry. Let me complete my statement.
My, sorry, my lord.
Come to page 19.
19, my lord. My lord.
When this ERO verification was made, you are a resident of Akabasti, Bengali,
Yes, my lord.
correct? Now please come to paragraph 5 of page 23.
My lord.
Opposite party is a citizen of India. She was born and brought up at village Budam Ghat.
Yes, my lord. My father
Now-
is there in Budambhat, my lord. And I was married to Akabasti, and thereafter we both are shifted to my father's residence, my lord.
Correct.
My lord, everything is there, my lord.
Okay. Now come to page 33, 32.
32, yes.
Village Bomaguri.
Yes, my lord. That is the
1966
initially my grandfather is there in Bhomoraguri, my lord. Bhomoguri. and thereafter my father was shifted to, my father name is also there in 71 till 71 in Bomoguri, Milo. Bomuraguri, page 34, Milo.
Yes.
And thereafter, we are in shifted Gudam Ghat, Milo. And I married with Akabosti, Milo. And thereafter, we are shifted in father's place now. That I got married so in 2002 with so and so, Akabosti Bengali, so and so, para 2, page 36. So and so. But after 1 year of marriage, I, along with my husband, came back to my parental place of the residence. Since then, I have been continuously residing at my parental place of residence, village Gudam Ghat, PS, Saridwar district, Sonipur, Assam, having permanent dwelling house therein. This was the DWD1, my lord. Petitioner, my lord.
Where have you, in which page of your written statement you have referred to the shifting of your father?
No, before expired my father.
No, that we don't know, but where have you made that heading? Because you have shown you the documents and paragraphs.
Yes,
Now, where in your written statement you have said that your father shifted?
My father, Abu Baskar, son of so and so,
Reading where?
is
Which page you are reading?
page 37. Para 5, my lord. My father, Muhammad Abu Bakr Siddiq, son of so and so is a bona fide citizen of India, was earlier resident of village so Bhomuraguri, PS Tezpur district, Assam, and was also a voter of the 77 Tezpur LSC, having his name appeared in voter list 1971 Shell number so and so, wherein his name is written is Abu Bakr Siddiq in the place of Abu Bakr Siddiq. Due to some bona fide mistake later on before my but he came to the present place residence and had permanently settled there and had got his name annual voter list of 74 Rangapara LSC. My father is presently a voter of 76 Rangapara LSC possessing electoral photo identity card. His name so and so, the name of my father and mother, Anwara Begum, including my name and my husband name have appeared voter list 2010 of 74 Rangapara LSC, so and so, house number 66, and also have been exercising voting right regularly for the said LSC. The certificate of the electoral vote showing the name of myself, my father, my mother, and my husband. My grandfather, late so and so, was a bona fide citizen of India, was a permanent resident of Bhumraguri PS, Assam, and was also voter D 77 LAC, having his name appeared in the voter list so and so, and used the exercise his voting right regularly for the said LAC. He died in the year 1970.
That is your grandfather. That is your grandfather.
My lord. Pardon, please.
That is about grandfather.
Grandfather, this is a grandfather, my lord. And my father also pays 39 annexure 9, my lord. This is the written statement. That was also not denied by the opposite party, my lord. And there is no in government council, my lord, at that moment. And I also annex, my lord, school certificate, my lord. Page 27, annex up 4, my lord. Certified that Miss Mamtaz Begum, daughter of Muhammad Abu Bakr Siddiq, an inhabitant of village Gudam Ghat, P.O. Silonigao, P.S. Rangapara district, she was reading in class 8 and had passed, but she could not come out successful in the same. All sum due her in the school have been so and so. Her date of birth according to admission register is 5185, remarked as sort of character and reason for leaving minor reason, my lord. And headmistress also given the statement before the tribunal, my lord. And that was also not considered by the tribunal, my lord. And in respect of my lord, last national register NRC, my lord, our whole family name is there, page 54, my lord. Your lordship, go to.
Well, mainly on the ground of delay. Delay is not properly explained by my lord. The lordship will find it para 18. They say that father survived up to 17/5/2019, died in 2019. So we admit, my lord, we should admit that father was ailing, my lord, so she could not approve. Thereafter, my lord, what happened thereafter? The explanation is back thereafter. Up to 17/5/2019, I accept, my lord, there is some explanation that his father, her father was there ailing. He was suffering from it. And after 2019, there is no explanation. Only explanation is that it cannot be ground of delay. There is lapses on the part of the people.
Pardon me?
There is lapses on the part of the.
I think there is no rule, my lord, specifically on my lord. Parliament is silent regarding the.
Had there been no process of deportation, they would not have come. That is the simple thing.
Okay, we'll examine in parts of those.
My fear is that, my lord, if delay parties is, my lord, is not condoned, then I know I have some request time for submitting some judgment. The maintainability part of the lordship decide. Then
Whatever we want, we can't say. Right now, what we are. When we pass orders, we don't know what orders will be passing after some time.
I-
If you want to rely on any judgment, you give it to the court master.
my fear is that, my lord, call for the record, my lord, if this my whole facts is genuine, my lord, then I have some that your lordship may consider regarding that issue. And she is a class 8
We
pass, my
consider
lord.
and pass orders, but if you want to rely on any judgment, please give it to the court master. Don't take a chance if you don't know what will happen.
I'm sorry for that. In this case, my lord, call for the record, my lord, and thereafter, my lord.
We can't. You see, we are not passing the order right now.
My lord.
We have not thought what we will do.
My lord,
It will depend on when we retire and we'll both discuss.
my lord, I'm sorry for that. I'm sorry for that,
No, you would be sorry for that.
my lord.
You are sorry because we are retiring in the room and then dictating order. No, don't be sorry for that. But if you want to rely on any case laws, please give it. We'll pass orders in.
Matsuri.
Thank you.
Yes.
Your lordship. But at that opinion, your lordship will find at page 66, madam.
67.
66, madam.
is dated 31st May 2024.
Mr. Ashok. Mr. Ashok, Land Council for the petitioner. The respondents are there. Opinion is at page 66. 31/5/2024. Passed by so and so in FT case number so and so. Arising out of SP order reference number so and so. Thereby declaring the petitioner to be a foreigner post 25 in 1970. Notice returnable on same date. Extra copies in included call for the relevant report from the consent tribunal. The period for bail shall be considered on receipt of the government reports. Next, in the meantime, if the petitioner, namely Rehana Begum, REHANA, Rehana Begum, is apprehended, she shall not be deported out of the country without order of the court. List on so as.
Madam. Obliged.
Please, Your Worship, the open revision impugned by page 72, it is 27/3/2025,
Page number.
page 72, ma'am. Order opinion dated 27/3/2025.
Mr. FKR Ahmed, Learned Counsel for the petitioner. All the respondents are there. Opinion date, page 72. Dated 27/3/2025. Passed by so and so. In case number so and so, reference number so and so dated 4/4/1999. We were declaring the petitioner to be a foreigner post 25 in 1971 Spain. Notice returnable in 4 weeks. Call for the record. Prayer for bail is opposed by the learned standing counsel to the FT matters. So, however, considering the projection made in this picture, 10 days time to take bail of rupees 5,000. Please accept now. Superintendent of police border.
Sonitpur. Sonitpur test.
1, 2, 3. Okay. So we will not be able to pass orders. We have to amend your petition. You will have to come again. Ask this. Is the nomenclature of respondent of 5 does not exist. To this time is granted to the petitioner to in the cost in respect of respondent of 5.
Respond number 6, my lord. Respond number 6.
5. Deputy Commissioner is no longer there.
Yeah.
You to simply. So, I officially titled hostility to the learned AOJ, sorry, to the AOJ FT sector for the properly investigation. This is the matter in the motion column immediately thereafter. We have to amend the cost title.
We have to remove the respond number 6.
No, I'm not asking for removing. Is the Deputy Commissioner available now? No.
Come on, you are writing respond number 6, my lord. He is a Sugandha police border. Yes, Sonitpur.
Is respondent number 5 available now?
No, not available, my lord. Not available now, my lord. So that I will do, that I will file, my lord. But in
No, amend it. No orders without that, because otherwise there will be a wrong cost title coming in. Amend the cost title. Instead, after once you do it, it will come.
Malala, in this case, the biometric of the petitioners has not been taken. And when the matter was our first time, Indian order has been passed that he should not be detained and deported. So Malala, that should be given, he should appear before the SP given his biometric and he will appear before the SP, my lord. Page order dated 1/10/2018, my lord.
No, you respond on merit.
Right.
You've already listed for admission. Which page is the impugn opinion?
Page 41, my lord.
41. Yes.
No, if your lordship permits, my lord, this matter may come on Thursday, my lord. I need some. Really, I don't have the file on. Right. My lord,
छोटे पेपर হয়ে যাওয়া বান্দা কাজ ছোট বান্দা কাজ হয় ফলে হইল যেটা বিক্রয় হবো না তার বিচারই না কখন হ্যাঁ এটা কথা আপনার বিচারই না হবে এগুলো এটাকে যেটা বান্দা খাই যাবো না তার নাম let the petitioner appear before the SP, giving his biometric in the meantime. That option. No, no, that is, then that order will continue, my lord. Otherwise, that order, other interim order is continuing. SP Morigaon. Morigaon. SP border Morigaon. Hello.
Ask Mr. Hazarika to find him out. Take it after some time. After some time. Senior committee. Just wait.
Well, no problem.
May please, Your Lordship. In order, Your Lordship, case 46. The reference is made against the 5 family members of the petitioner, but in the meantime, father and mother already expired. And petitioner's two sisters, 4 and 5, Gita Sohan and Tasohan, are Indian citizen. And only against the opposition, the person of 3 years. The contest is the case. Father and expired. Local.
Where is your written statement?
This statement, Your Lordship, page 37.
Please come to page 37. This is your written statement, and here you have not made any statement that you belong to Azamgarh.
It is not mentioned.
You made a statement before in the proceedings that you are from Azamgarh.
So
You say that
originally,
the
this that I
police
was asking-
recorded wrongly that you are from Bangladesh.
in the inquiry report, Your Lordship, page 34. It is said that since 1970, they are staying at Phuket. Page 34, inquiry report, and from the same family members who are declared that they are not foreigner in only period. Page 34, and serial number, Your
34.
Lordship, 7 and 11.
Does she has on any land, so and so, serial number 7, yes, Five Fatal and Tangapar since 1970. And serial number 11, since when she is staying continuously in India since 1970. Seventeen also, Supreme Court says that petitioners two sisters, they are Indian. Only father, mother, and petitioner is foreign. My parents may appeared in the total is 1970 and 71. And along with my parents in the total is of 1993, my name is there.
Where is your first voter list?
Well, 1993, Your Lordship, page 18,
Age?
18. We start from 17, 1993, page 18 is my name is there. Along with my parents there. Vasantostami, father, mother, then three other children.
Okay, you come to the merit also.
But my parents' name appeared in the Procedural 1970-71, which is 13. The type copy. My parents' name,
Page number.
13, type copy. Procedural 1970. Father's product name. Then Procedural town, 70. Next case 14 is the family product. And case 15 is the totalist of 1971, that we accepted. Next 93, my name is with the parent. First time with you.
Which page?
Page 17 and you start from 17, 1993 totalist, my parent. Page 18 is name of the parents and petition. That's one below. Because that town, what number 2. Second total is also there, 2005, case 20, 19 and 20. With my mother. So my father expired in 1996. I annexed the death certificate is 25. And my mother expired 2012. That was after 93, my name appeared with my mother. 2005 to 2000 I have annexed. Case 19. With my mother and other. My mother from Clerical.
Yeah.
Proof that before 1970 part of the is there. 1970 Buddha's parent is there. And references made against 5 family members. Out of 5 left that out of 5 2 are Indian and 3 are the reference also said in the report that since 1970 they are staying at Kolkata. Just proof. Just proof is saying that before part of it is staying here.
Right. Page 46 onwards, this exhibited documents. Is there any other document on record? Because this is not exhibited, not marked as exhibit. These are photocopies. And the tribunal writes at page 47, fourth paragraph, that all the documents are not duly certified. So if this exhibits are excluded, you have nothing. Take it up. Is there any other exhibited documents on record? Please find it out.
These are the documents, ma'am. These are the same document. Yeah. No. Yes. Yes. Ma'am.
Yes. And all the documents are still not duly certified. No, that means, no, that means that maybe you are digitally signed, that may be that's not, not certified means the authority, the issuing authority. Tribunal view is the issuing authority, not certified. But
Sign.
that total is your digital not report to prove your. And this total is your digitally signed. Not record to prove your, the note your, the certificate page 16. Page 16. Note your bottom signature, the digital signature. The certificate is digitally signed and here no needs physical signature. Authenticity of this certificate can be verified from the so-and-so website verification. The certificate is legally valid as per the Information Technology Act 2022 in the certificate amendment. Tampering of certificate will be after the pattern. It's not required to sign. They are already digitally signed. They will not say that this is not a certificate copies. Next page also is 18. It's not a fake document. The system are now digitally signed. And Tribunal can verify and WhatsApp number also there. Earlier there was signatures there. Nowadays they this type of digitally signed all totally are. They're not required to. Tribunal cannot say this is not a certificate. Not duly certified. Earlier Tribunal said that all the document not duly certified. It is wrong. It's not correct. Digitally signed document. Observation of the tribunal is wrong.
understand, verify also this document.
Mr. Islam? Please try to scan and check that voter list of
71 and 90.
1971, which is there after page 46 and page 46. Is it a certificate copy or it's a photocopy?
Is 15 at the top of the application. Number also there, certificate number, application number, date, everything is there. Is 15.
Available journal. I take it from website. I don't think it is a certificate, it is a Xerox copy, maybe, it is a Xerox. It is scanner, it is coming. It is scanner, it is coming. Even though it is Xerox, from Xerox also it is coming, because from this page also, my lord, this copy also it is coming. From this copy also it is coming. Yes. Yes. Then, no, scanning it is coming. No, scanning it is coming, what it, from there also it is coming. Next page, next voter list also it is coming in this page. Yes, 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 from my copy also. Yes, yes. Yes. Original. It will original, I don't know.
You will need copies. You will need this record.
Record.
Outside the represented. From the records received from the London Tribunal, it appears that some of the voters list that It appears from paragraph 4 of the opinion that the learned tribunal has observed that all the documents are not duly certified. Already covered. Court had requested the Mr. M. Islam, the counsel appearing on behalf of Mr. A.R.D. standing for the Election Commission of India verify as to whether the documents contain. That's not documents. Copy of voters list available in the report. Photocopies are original. Next, counsel appearing for the appearing on behalf of the Roman standing for the election commission. Based on permit the custody of the report. Custody of the concerned voters list for making an plan. There is the law that court officer provide copy of Mr. Check provide the relevant of the Mr. M. Islam hearing on the election company. Next, this or right. Market for the original, the documents which are there, we'll give it to you. Not nothing.
Well, the meeting has taken place. Lot. Meeting. एक अकेला में होगी और एकदम मीटिंग पर हो गई ओके मेरा काम फोटो मतलब हो गया Lachi, the meeting has been taken place, and the finance department has already
instructed the Home and Political Department to release the amount, this amount. Kindly, I'll just place the decision. Kindly, if possible, take it tomorrow. Tomorrow. Or day after tomorrow.
We take it up on Thursday.
Lodge.
Because we are, you see what happens in the government, we are not more interested. We just want that this petitioner should get the.
In the meantime, because the meeting on last occasion when the matter was taken place, on that day itself, the meeting was there. In the meantime, I'll also take the instruction what they have done. Because political department has been directed to release the amount of 2 lakh rupees as directed by the petition.
No, it's a problem.
What?
Both sides are represented, right? Mr. D. Knapp, the senior government advocate has something that pursuant to the order passed by the court. The finance department as well as the home and political within bracket lead, but this is
Not.
not the home and political.
The meeting held on 21/7/25.
With a meeting on
21/7/25.
21/7/2025, in place for some time to obtain instruction.
But
Relating to the release of the interim conversation with the petitioner.
No.
Questions I come to the test. Easy. Oh, no, 31st, 31.
Okay.
My last item 41, this matter may can be taken another day.
No, all of the matters will be adjourned because we'll have to rise for the single bench. If there is, we'll have to rise for the single bench. If you have some urgency, please tell the court master. We'll take a call because this week also we had some disturbance. Want to say something?
Lord, I'm waiting for item number 24.
We said all.
Hello.
No, only one party was not there. Who was not there? No. The area respondent, one of the parties did not appear. Okay.
May please, my item number 31.
The court master. Please tell the court master because this week there's some disturbance. There will be some disturbance with the project.
Let me be fixed, my.
No.
Please tell the court master.
Okay.
Because I'll have to rise for the single.
Okay.
Please, Your Lordship.
Yes.
Yeah, this is second bill application, Your Lordship. The petition number 1 was arrested on 27/7/2022, Your Lordship. Exactly 3 years, 1 day today, Your Lordship. And petitioner number 2 was arrested on 22/4/2022. 3 years, 3 months, 6 days, Your Lordship.
And petitioner number 1 is the year.
3 year, 1 day. 2 is 3 year, 3 months, 6 days. FIR has been lodged under section 121, 121A, 120B, 124A, read with section 17, 18, 18B.
Present stage of trial.
Yes, it's the state of trial, Lordship. Only 6 witnesses has been examined till date, Your Lordship, out of 25 witnesses. And the first witness was examined on 1/10/24, Your Lordship.
And then last was page PW six was examined, was examined on 21 to 25, Your Lordship. And 17 to 18 occasions, witnesses were called, Your Lordship. But either the prosecution has failed to bring the witnesses, and or sometime, Your Lordship, the presiding officer is on leave, Your Lordship. They have been languishing in jail since then, Your Lordship. And the trial may also take some time to complete, Your Lordship. On that ground, Your Lordship, as they have been in jail for so many years, Your Lordship, and they have almost spent their 3 years in prison, Your Lordship. If they have been, the punishment is under section 18, they have been charged under section 18 and section 20, Your Lordship.
Like,
At page number 8, Your Lordship, I have stated the charge frame, Your Lordship. Again, petitioner number 1, Abbas Ali under section 121A, with section 18 and 20 of UAP Act, and against petitioner number 2 under section 121A, IPC, with section 20 UAP Act, Your Lordship. And on perusal of the charge sheet also, nothing can be seen that, Your Lordship, they have committed an offense, Your Lordship. Only at page 39, Your Lordship, of the charge sheet, 3 witnesses have stated that they have seen one person residing at the house of Said Ahmed, that is petitioner number 2, nothing more than that, Your Lordship. After arrest of the petitioner number 2 only, they came to know that the person who was residing at the house of petition number 2 residence is a ABT cadet, Your Lordship. Which is not a bank as per organization as per schedule 2, Your Lordship. May I read the statement of the witnesses, Your Lordship?
not required.
Yes, Your Lordship.
It's like I was.
The 6 witnesses, the examination, nowhere they have stated the name of the petitioner, Your Lordship. Involvement in the organization, Your Lordship.
How many witnesses were examined?
6, Your Lordship. Out of 25, Your Lordship. And the time may take some more years, Your Lordship, to transmit, Your Lordship. And they have almost completed 3 years of their imprisonment. 9/5/25, your lordship, 3 witnesses were present, your lordship, but the PO was on leave. That's why they were sent back. Hmm? 31 second. I see it. 30. 24.
In this chart sheet, in this case, it appears that police suspect that they are members of a band organization. The materials corrected against them except for oral statement. You're saying that there are two books per search and found in the premises of one. It refers to I'm saying we had except that is there any other material against the previous person?
Today I could not go to address city purpose, but I can recall, you can recall that earlier at the time of bail, I have controlled the city. In this case, Lordship.
You can have it if you want.
In that case, Lordship, there are materials, Lordship, against them. There are some direct implications are also there I have found. If that case is, so that I can recall that I have recalled the city purpose. How they engage persons in their organization, that is also there, where money comes.
Probably if you want to take it, take it, this is matter tomorrow.
Or day after tomorrow.
Day after tomorrow, there will be a long list in the petition bench. Very difficult tomorrow.
There is some program that my home.
We are giving you custody of this. Handcuff. Miss
Yes, Nazneen.
S.
Nazneen.
Yes, Adli. If the handcuff of the record received is not available, same is handed over to Mr. P.S. Becker or APP. So is the same as just let it wait with the. It's not. Yep.
Day after tomorrow.
8.
On 30th. 30.
Day after tomorrow would be.
30. 30.
Yeah,
Please, a pleasure.
Yeah, I was directed to take instruction from the IO Lordship, whether he.
No, I can see the review petition.
Only
I think Higher Education Department. You there?
My lord, this honorable court was pleased to dismiss the lead petition in WBC number 1690 of 2018 with cost of rupees 10,000. And accordingly, the petitioner has deposited the cost, my lord, before the principal of the college. And now, my lord, the petitioner is preparing this review petition, my lord, only for reconsideration of two aspects, my lord. First one is, my lord, seniority of the petitioner over the reference number 4, and my lord, the cost part. As petitioner pays for, still the same as donation. Here, my lord, the petition has been dismissed. And this aspect was considered, my lord, aspect of seniority was considered that the petitioner initially joined in non.
Is there any incorrectness in page 160? Paragraph 12. Is it wrong?
No, my lord, I am not time for reconsideration of this aspect.
Then you can respond.
Only my lord, seniority, my
No,
lord.
because respond to 4, we have held that he was senior to you.
My lord, what happened, my lord? The petitioner is joined initially in a non-sanctioned post, my lord. And later on, my lord, on 8/1/1998, my lord, against the lien vacancy. But through a, my lord, regular process of selection, advertised interview, my lord,
That
selected,
was on 18/7/99.
my lord. And thereafter, I was, my lord, confirmed, regularized on that post, my lord, 18/7/1999. On the basis of, my lord, the condition stipulated in the advertisement. But your lordship may kindly see the advertisement. My lord. page 163, NXR 163. Yes. Applications with full biodata and attested copies of mark sheets and certificates from SSLC onwards are invited on the candidates having UGC norms for the post of a lecturer in English for a period of 1 year, leave vacancy, but likely to continue permanently at UGC scale of pay and allowances. Candidates having special paper in linguistic and belonging to scheduled caste or scheduled tribe will be prepared to fill up the backlog. Now, my lord, I am referring to the line, my lord, but likely to continue permanently at UGC scale of pay and allowances. Later on, my lord, the incumbent who went on lien, my lord, he did not join, my lord. And accordingly, petitioner was, my lord, regularized against the same post. And my lord, service book also refers, my lord, the continuation of service from the date of his initial joining on the said lien vacancy. And I am relying upon a decision, my lord, in this regard. That is, my lord, reported in AIR 1990, Supreme Court 16079.
And 1990
1990, my lord, 90.
SC.
SC, my lord, 1607. I would like to draw the kind attention of your lordship to paragraph 13. Internal page 8. Yes. When the cases were taken up for hearing before us, it was finally suggested that the principle laid down in Patwardhan's case was unsound and fit to be averred, but no attempt was made to substantiate the plea. We were taken through the judgment by the learned counsel for the parties more than once, and we are in complete agreement with the resident that the period of continuous obligation by a government servant after his appointment by following rules applicable for substantive appointment has to be taken into account for determining his seniority, and seniority cannot be determined on the sole test of confirmation. For as was pointed out, confirmation is one of the inglorious uncertainties of government services, depending neither on efficacy on the incumbent nor on the availability of substantive vacancies. The principle for deciding interstate seniority has to conform to the principle of equality spelled out by the Article 14 and 16. If an appointment is made by way of stopgap arrangement without considering the claims of all the eligible available persons and without following the rules of appointment, the experience on such appointment cannot be equated with the experience of a regular appointee because of the qualitative difference in the appointment. To equate the two would be to treat two unequal self equal, which would violate the equality clause. Now, my lord, I am relying this part, my lord. But if the appointment is made after considering the claims of all eligible candidates, and the appointee continues in the post uninterruptedly till the regularization of his service in accordance with the rules made for regular substantive appointments, there is no reason to exclude the officiating service for purpose of seniority. Same will be the position if the initial appointment itself is made in accordance with the rules applicable to substantive appointments, as in the present case. To hold otherwise will be discriminatory and arbitrary. This principle has been followed in innumerable cases. My lord, this principle has already been considered by the Honorable Decision Bench of the Honorable Court of Law. I would like to refer to the paragraph 44, my lord, of this same judgment. internal page 24, my lord. Paragraph 44, my lord. 44. 44 of the judgment. I'm relying upon B mainly. To sum up, we hold that once an incumbent is appointed to a post according to rule, his seniority has to be counted from the date of his appointment and not according to the date of his confirmation. The corollary of the above rule is that where the initial appointment is only ad hoc and not according to rules and made as a stopgap arrangement, the officiation in such post cannot be taken into account for considering the seniority. Now, if the initial appointment is not made by following the procedure laid down by the rules, but the appointee continues in the post uninterruptedly till the regularization of his service in accordance with the rule, the period of officiating service will be counted. So, my lord, in this case, the present petitioner was appointed by following all the procedure as per rules, my lord. And my lord, hereafter, he was regularized in terms of the, my lord, the condition stipulated in the advertisement. So, my lord, his seniority is required to be counted from the date of his appointment against the lien vacancy, against my lord lien vacancy, where he was appointed, my lord, on my lord 8/1/1998. But my lord, at the time of my lord argument, the petitioner could not bring this aspect, my lord, before this honorable court, because the advertisement was also not, my lord, annexed in the earlier petition. I am saying for reconsideration of this aspect, my lord.
Phone number 8. I think watching the is only a comment party. It's an internal matter of that college concern.
Now, I am not insisting that part, my lord. But lots of that are being decided, sir.
Is wanting to press only for the purpose of seniority.
Right.
What do you say about that? Still, you are not. It will not be for you. It will be for the respective college to say. You are not appealing to the college.
No.
Department of English, RPG College. You are appealing for education department. Are you also appealing for this RPG College? What is your instructions on this issue of seniority? Who's appealing for college?
Earlier, my lord, J.M. Gogoi, Learned Council for Restatement number 3 and 6. 6 is the, my lord, governing body of Bapuji College. Learned, Mr. D.D.
Who is
Gosai,
appealing?
my lord, test 156, my lord.
Seven is Mr. V.D. Goswami.
Yeah.
College was V.D. Goswami. Have you served a copy on him?
My lord, we went to serve my lord, but he refused. Because the brief has already been taken. In that case, my lord, we will accept my wisdom of this. We may be directed to start copy, my lord, and we start.
Their responsibility required 6 and
My lord,
7.
and the response of my lord, assessment number 4 is also required, my lord, because his seniority will be.
You have not
affected.
issued notice as yet.
No, my lord. In review petition, my lord, no notice has been.
This Mr. Madhav, we issue notice then. You have not issued notice on this matter. We issue notice then. Let me say you did that and talk to them. What's the file? It's we have not done it. Standing person for the education department, representing respondent number 1, 2. One and 2. As well as Mr. T.J. Fukan and standing person for Guwahati University, respondent number 8. The petition is review petition. Is direct. Yes. The order dated 21/4/2023 passed by this court. WPC 69 of 2018. By which the petition was dismissed. However, on a token cost of rupees 10,000 against the petition. Next. The limit market for the petitioner submitted. The present review petition is fully directed to make a claim against the claim in respect of his seniority over respondent number 4. And as regard the position of cost. But then we'll have to hold that the review is not maintainable. The reason is very simple. That's why we asked you about that. You see the date of inquiry, the date of appointment, we held that he was senior. That goes to the merit of the matter.
But my lord,
In a review, we cannot alter the merit. It is only to
no, my lord,
only in respect of omission.
but my lord, the lordship hold that. Observe that, my lord.
If there is a judgment, that cannot be a ground to renew the matter.
Lordship may kindly see paragraph 7 of the judgment. One.
Paragraph 7 is the impugn order.
My lord.
Yes.
It may be mentioned that in paragraph 4 of the petition, the petitioner has admitted as follows that there is no dispute that respondent number 4 say Kumar Sharma joined the department against the regularized post before the petitioner making the respondent number 4 senior to the petitioner for getting promotional benefit before the petitioner. Thus, in absence of any material on record to show that seniority can be reckoned from the date of appointment in a non-sanctioned post, the seniority of the petitioner in service must be counted from 18/7/1999, the date on which his service was regularized against a permanent post. In this regard, if one wants an authority, here, my lord, we fail to bring to this notice to the notice of this honorable court, my lord, any rule, any authority that to count the seniority from the date of my initial appointment. That is observed by this honorable court. If we succeed to place this matter properly, my lord, then your lordship may take another view.
So is this, is the contents of paragraph 7 wrong?
No, my lord, I cannot say wrong, my lord, but because we failed to place our contention properly or the matters properly, and my lord, the advertisement was also not placed before this honorable court, my lord, at that time. So your lordship was not aware about the tax matter due to our inability. That is why we have become.
Please come to the grounds of review where you have stated this about this.
Never. Regarding our inability, my lord, we have stated in paragraph page 23, my lord. Regarding inability. Page 23. For that, while the impeached judgment and order dated 21/4/2023 was passed, the review petitioner failed to bring the important relevant particulars to the notice of this honorable court. And due to the inability of the review petitioner to bring into the notice of this honorable court, an error apparent on the face of the record has been stretched into the impeached judgment. Which requires reconsideration.
Has to know the parameters of review. It must be an error apparent on the face of record. And if you have failed to produce something before the court, then you must also show that despite due diligence, you were not aware of the same. You can't come and say when you are in service that I applied by virtue of an advertisement and I don't know about the advertisement. You must show that despite due diligence, it was not within your knowledge. That is the first requirement for review. When you seek a ground of review that you did not place appropriate materials before the court. How have you tackled with that?
Kindly see page 157. Page 157, paragraph 4. 157.
57.
Paragraph 4.
Yeah.
The learned counsel for the petitioner has not been able to show from the provisions of the provision of any act, rules or notification that seniority position of lecturer has to be counted from the date of joining and not from the date when they were appointed in a vacant and sanctioned post. In the said regard, my lord, it is to well settled that the period of service rendered in non-sanctioned post shall not be counted for seniority in the other purpose.
Then there would not be a ground of review. You see, for a very simple reason. Your advertisement says that this is a leave vacancy. And this leave vacancy may turn out to be a permanent vacancy. But can an appointment of leave vacancy be bracketed as a regular vacancy without there being an order of the authorities? This leave vacancy will have to be converted to a regular vacancy.
My lord,
Can appointment made in the leave vacancy be regularized as a regular vacancy?
but it is regular, I think, regularized by an order. That is by the authority. And without it going, yes, my lord, recruitment process, my lord. I will my post was regular.
So, therefore, from regularization.
Right.
In the case you were cited,
My lord,
in that case, there was an amalgamation of the service.
Right.
And therefore, they were appointees to be set higher post from two different cadres under two different service laws. And therefore, it was said that one comes, therefore there has to be a merger at one point of time. Under that context, this judgment was passed. Correct?
my lord. Not by the my lord principle laid down in the judgment, my lord.
No, judgment, one paragraph doesn't make the law.
No.
It has to be decided, the judgment is a authority on the facts on which it is decided.
No.
So, please assist us in the question of law, not as a counsel
It
for the
should
university.
be
First place.
apparent on the face of the record, my lord.
Means, the query is that, you see, there is a appointment is of leave vacancy.
Yeah.
Leave vacancy, there is no order showing that leave vacancy was treated to be a regular vacancy from the antedate.
Yeah.
So therefore, it has to be from the date of what you call date of regularization.
Lord, I could not recollect, there is a judgment of this honorable court regarding one Cotton College lecturer. He, my lord, served in temporary capacity, but that was counted for seniority aspect, my lord. On Damodar Das or Bhuya, my lord. Next date is, my lord, I will place that judgment.
Damodar Das, I think also it is there.
Damodar. Yeah. Das take a Cotton College lecturer.
Yes, Assam College Employees Provincialization Act. No, this is Rangia College. No.
No, Cotton College.
Cotton College or Cotton University?
Cotton, at that time, Cotton College.
Cotton. Gangadhar Das.
Damodar. With Das or Bhuya, my lord. I've forgotten, my lord.
He served in a non-sanctioned post.
One Supreme Court case has also been relied upon.
You take it on foot then, this address us. It's only for the purpose of notice, then you are married. You'll rely on the research made by Mr. The facts and circumstances of the case. Put query is to the effect that if the petitioner has joined in the post of lecturer in English in a leave vacancy of 1 year, and the advertisement reflects that the leave vacancy may continue permanently. Can order of regularization be treated to be one when the leave vacancy arose? When the petitioner first joined as under the re-vacancy. Said for request the Mr. P. The Spanish for the guardian practice. This query is only for the purpose of issuance of notice on the respondent. The question would be whether, even if we take that view, can a order be reversed in a review jurisdiction? There again, it is a negative. There's not one, there are these three judgments I have. It says that the judgment can be overturned and deeply affected.
Most of them.
Yes, item 4. Yes, Mr. Raghav.
As per direction of this honorable court also, I have received a report from the IO regarding his appearance in the report.
What does it say there?
It says also that they have no objection if he is being allowed to come appear before the IO whenever his appearance is required.
Okay, then we'll do it. But
He is regularly appearing there.
you will have to provide your phone number and your address. And if you are out of station, you inform the.
If I reside in Kathar, I will provide all my contact details.
Okay. And it says they learn from the applicant. Also heard Mr. P.S. Lagar, I know the DP, for the state respondent. Next one. I think this interlocutory application, the applicant has prayed for modification of the conditions contained in the order dated 25/1/2023, passed by this group in GA number 11 of 2023. Five conditions on which bail was granted for order to be 25/1/2023. The relevant conditions of which modification has been paid for are condition number C and E respectively are quoted to you. As against those conditions, the applicant had paid for modification of those conditions and by order dated 11/4/2023. The said to continue passed by this court in IA criminal number 280 of 2023. Said conditions C and D were modified as follows. C and D. Next. Case of the applicant that he has been complied with both the said conditions for more than about 2 years. And as is presently not be questioned by the IO. On the case that the condition of appearance be modified, but it is becoming difficult from petitioner to defend the IO after every particular case. You get to take. If you get to travel from I think the travel form. Now, as you connect you part within packet Singapore. Located on the description of Solar Police Station, you are case. Next. Person to the. Auto previously passed in this. So, pass from, not previously, pass from 26 is right. After the evaluate case. Instruction. Says that the petition has been appealing to the IO in terms of the conditions imposed by this court. And the IO is yet not the petitioner the text to appear before him as an recall. Taking into account the statement made by the petitioner that would not be currently interrogated. For the nature of instructions sent by the IO to the learned entity, appreciated. The number C and D of the order dated 25/1/2022 passed in EA 7 of 2023 as modified by order dated 11/4/2023 passed in IA criminal 280 of 2023 modified as under C. The petition shall not leave the jurisdiction of state of Assam without prior permission from the investigating officer. Now, state of Assam will not leave the state of Assam without providing this particulars of its travel and stay. The petition shall provide his contact number and email number. The investigating officer. As well as undertake before the investigating officer to appear before the present when notice is received, if the notice from the IO is received. Either the messaging application to file. The charge sheet is not yet submitted.
Okay,
it will be filed, progress and FF will be submitted after completion of the required follow-up.
This order shall be read together with all witness. Applied on 23, passed in 7 of 23, and 11 4 23, passed in 5 to 80 of 23. Applicant shall produce a certified copy of law for the investigating officer of the crime branch case case number 3 of 2. In the order to the set to provide the particulars of telephone number, email. Shall be done within a period of 10-15 days. Period of 15 days from the date of your. Next, the IU is at liberty to apply for modification of the order in the event there's any default by the applicant. Abiding by the conditions of the next consequence. Take it to part of the instructions of the IO.